taken by the Cabinet and it was not taken by the Minister. My Lord, I give you the references in 2.1, but with your Lordship's indulgence, I would like to just take your Lordship through them. So the first set of references, my Lord, is to the founding affidavit in paragraph 119, and there the following is stated. On 5 December 2024, the Minister responded to ETV, MMA and SOS, indicating that he would meet with broadcasters at 1:30 on 5 December 2024 to provide an update on ASO following the Cabinet meeting of 4 December 2024. So there was a Cabinet meeting on 4 December, the Minister calls a meeting the next day at 1:30 to provide an update. And then the founding affidavit says, at this meeting, a transcript of which I attach as FA23, the Minister announced that Cabinet had resolved to postpone the ASO deadline to 31 March. He indicated that his department would produce a plan after a transparent consultation process with stakeholders to ensure BDM before 31 March 2025. Now, my Lord, we have provided the court with the transcript of that meeting. Again, it's in 2.1, it's Annexure FA23, and there it is absolutely clear, this is in the Minister's own words, in which he said the following: Cabinet met yesterday, and the resolution by Cabinet's decision around the deadline of 31 December was to grant a postponement until the end of March 2025. So the resolution was to postpone by 3 months and to let the end of March be the final deadline with which we will be working with regard to the analogue switch-off. My Lord, the second set of references, again pointed out in 2.1 of the heads, is to the founding affidavit in paragraph 129.3. There it is said, on 14 January 2025, the Minister appeared on television for an interview on ASO, and a transcript is attached. And in 129.3 it is stated, the Minister explained that Cabinet approved an extension of ASO from 31 December 2024 to 31 March 2025. He said in plain terms, Cabinet has made the decision, and my Lord, we provide the transcript of that, which indeed reflects that that is precisely what the Minister said. Now, my Lord, there is no dispute about this. The answering affidavit makes that much absolutely clear. And in answer, and this is in paragraph 2.5 of the answering affidavit, the Minister says this: whilst the decision to proclaim the analogue switch-off date was taken by the Cabinet of the Republic of South Africa, it was briefed by the Minister on the process that was followed up to the date on which the determination of the analogue switch-off date was made. For this reason, the President of the Republic will also be opposing this application and will inform the court of the basis on which the government opposes the relief which the applicants seek in this application. Now, your Lordship will recall at the case management meeting, a deadline was set for the President to file any affidavits he would wish to put up. None have been forthcoming, which has an important legal consequence to which I will refer in due course. But for present purposes, my Lord, there is simply no doubt that the decision to set the ASO at 31 March 2025 was taken by the Cabinet, not by the Minister. The law in this regard, we submit, is clear, having been settled by the Constitutional Court. The Constitutional Court has held, and I'm going to take your Lordship to the paragraphs in a moment, that the power to set the ASO is vested in the Minister and not the Cabinet. And if we are correct on this proposition, as I respectfully submit that we are, then the case for review is extremely strong. My Lord, if I could then take your Lordship to the ETV judgment on this particular topic, in which we submit the Constitutional Court was unequivocal that the power to determine the ASO vests in the Minister. We give your Lordship the references upon which we rely in 2.2, it's paragraphs 35 to 36 and 52 of the ETV judgment, but may I be permitted to take your Lordships to them. My Lord, starting with paragraph 35, the Constitutional Court said this: the regulations and the BDM policy, therefore, presuppose that the Minister has the necessary power to determine the analogue switch-off date. In my view, this power is located within the Minister's original constitutional policy-making powers, which is section 85(2)(c) of the Constitution. In the next paragraph, that's paragraph 36, the determination of the analogue switch-off date is the implementation of the BDM policy by the Minister. In my view, the Minister's exercise of power when determining the analogue switch-off date is thus executive in nature. And my Lord, then to paragraph 52. But before I read to your Lordship what is said in paragraph 52, I draw to your Lordship's attention the previous three paragraphs, that's 49 to 51, where the Constitutional Court articulates the principle of legality, which, as your Lordship knows, as being a fundamental principle of our constitutional law, and which holds that, of course, all exercises of public power must be sourced in law. So it discusses that principle, including a reference to the Fedsure case, and it culminates in paragraph 52, where the Constitutional Court says this: the decision concerning the analogue switch-off date is not a mechanical determination, as the facts of this case show. Important interests are at stake. Following Elbut, it was not procedurally rational for the Minister to set the analogue switch-off date without notice to the industry and affected parties like MMA and SOS to obtain their views on the matter. My Lord, may I add one further reference, and this is not in my note. It's a reference, my Lord, to the digital migration regulations. And just to remind your Lordship, the Constitutional Court says one looks to the regulations and the BDM policy to see what the Minister is or is not empowered to do. And if you go to the digital migration regulations, and my Lord, I understand it has the page to which I refer has been uploaded to case lines at 018-27, and it's the definition of dual illumination period. And what it says is this: dual illumination period means the period commencing on the date of digital terrestrial television switch on, as determined and published by the Minister, and ending on the date or dates of analogue television switch off, as determined and published by the Minister. So, my Lord, factually, there is no debate whatsoever that the decision was taken by the Cabinet, and legally there cannot, we submit, be any debate but that the power is vested in the Minister and not the Cabinet. Now, My Lord, there is a logical consequence which flows from this decision-making function, and that is the duty resting on the minister to consult with stakeholders, and again I quote from the Constitutional Court judgment, to determine the analogue switch-off date. In other words, the Constitutional Court has made clear that the decision maker is the minister and that a duty of consultation in relation to the analogue switch-off date rests upon the minister. And it is that consultative process which is aimed at ensuring that the decision maker, in this case the minister, makes a rational decision regarding the ASO. And it is for that reason that the minister is bound to hear interested parties, precisely because he is the one authorized to take the decision. And that is, in fact, precisely what is said in paragraph 52 of the ETV judgment, where, just to remind your Lordship, it is said that the regulations and BDM, my Lord, paragraph 52 says, the decision concerning the analogue switch-off date is not a mechanical determination. As the facts of the case show, important interests are at stake. It has to be procedurally rational for the minister to set that date, having regard to the interests which are at stake. Now, my Lord, to recap, the facts are clear. The decision was taken by Cabinet, not the minister. The law is clear that the power vests in the minister and not the Cabinet. And what we submit to your Lordship is that the legal consequence of the wrong person taking a decision are equally clear. My Lord, it goes back to the Fedshire decision, which was specifically cited by the Constitutional Court on the principle of legality, which holds that the legislature and executive in every sphere are constrained by the principle that they may exercise no power and perform no function beyond that conferred upon them by law. Now, the law, in the specific context of a situation such as the present, where the wrong person takes the decision, it is authoritatively established, and I quote, my Lord, from the Supreme Court of Appeals case, which I give you in 2.5, it's Minister of Environmental Affairs versus Cinematic, where the court said a functionary in whom a discretionary power is vested must himself exercise that power in the absence of a right to delegate. And that principle, my Lord, in Cinematic was approved by the Constitutional Court in Walele. And again, my Lord, I give you the references in 2.5. My Lord, the underlying principle that the right person vested with the authority is required as a matter of legality to take a decision, a particular decision, straddles in our submission a range of recognized grounds of review. I am about to refer to two decisions, my Lord, in 2.6. I alert your Lordship to the fact that both of them were concerned with the review of administrative decisions, but our submission is that the principles involved apply with equal force to executive decisions of the sort with which your Lordship is concerned. The first case, my Lord...
Before you proceed with those, as you're discussing this decision-making power and where it rests, to what extent can any person rely on the fact that if the minister is the decision maker, where national issues interests or policy making or policy implementation is involved, the minister may make the decision, but the nature of the decision making in government is in the form of cabinet ministers or cabinet meetings which take place, as we know, every week, and where a minister can then say, or it can be suggested by a party, even in this case, that the minister took the decision, but these matters are discussed because of the national importance and impact at cabinet, which then may endorse the decision taken by the decision maker, who is the minister, and then there may be a list of decisions that were taken in cabinet, not implying that they had departed from the empowering statutes or whatever legislative empowerment they have. And that is in that context that it is said to be a cabinet decision, because the final discussion was taken there. To what extent should anybody not rely on that assumption?
My Lord, we do not for one moment suggest that it would be impermissible for the decision maker, in this case the minister, to consult with the cabinet. Indeed, not only do we suggest that we accept that would be entirely competent, and in fact we would go further. We would even suggest, my Lord, that it would be a prudent thing to do, precisely for the reason that your Lordship has given, that there are extremely broad interests at stake, national interests at stake. So a consultative process with Cabinet is entirely permissible. What is not permissible is for Cabinet to usurp that decision-making function. And as I will indicate to your Lordship, and I know your Lordship is alive to it, it's absolutely clear on the facts, because they are admitted, they are borne out by the transcripts, that there was a usurpation of the decision-making power. So we accept without reservation that consultation with Cabinet is not simply permissible. We would accept that in many instances, and this is probably one of them, that it is not only permissible but even desirable. But what is not permissible, my Lord, as the cases make so abundantly clear, is an abandonment of the decision-making function. And that is precisely what happened here. And your Lordship's question, in fact, foreshadows and it is the error which the current minister once again makes in the present litigation. My Lord, let me be clear on around that particular date. And that consultation revealed, as was so graphically exposed in Parliament, that it was going to result in millions of people left in the dark. So, interested parties, and indeed Parliament exercising its oversight, was acutely aware of the very critical questions which the Constitutional Court had identified. What were the numbers of people who had registered? What was the rate of installation? How many people would be left behind? And the consultations all revolved around those critical questions with the secure knowledge that the date of 31 December had in fact been set. That stands out in marked contrast to what happened thereafter. Now, my Lord, just to complete the context, the Minister gave his presentation on the 19th of November, and relating also to your Lordship's queries about the role of Cabinet, 9 days later, that was on the 28th of November, the Minister simply announced that at a meeting of relevant broadcasters that Cabinet had decided that the ASO would remain at 31 December 2024, a date which the Minister had accepted just over a week before would have been irrational. Give your Lordship the reference at 3.7. And then what happened, my Lord, is that there was an exchange of correspondence with ETV pressing for an extension. That is at a time when everybody knew that the ASO was going to be 31 December. ETV and others were pressing for an extension to a reasonable date beyond that. And it resulted in the Minister convening a meeting on the 5th of December, and it was at this meeting that the Minister simply announced that Cabinet had resolved to postpone the ASO to 31 March 2025. My Lord, I give you those references in 3.8. It was thus presented, my Lord, as a done deal. That, my Lord, is the antithesis of what consultation on the date of the ASO required. Stakeholders were never advised that either the Minister or Cabinet were considering an extension to 31 March, nor were they invited to comment on whether 31 March was viable in light of the factors identified by the Constitutional Court as being critical to such consultation, or indeed any other relevant factors. My Lord, I give your Lordship the references in 3.9. My Lord, perhaps I should take your Lordship to that. We first, in 3.9, refer to the founding affidavit at paragraphs 174 to 175. There, in the founding affidavit, it is said the Constitutional Court in ETV held the decision concerning the analogue switch-off date is not a mechanical determination, as the facts of this case show. Important interests are at stake. It was not procedurally rational for the Minister to set the analogue switch-off date without notice to the industry and affected parties like MMA and SOS to obtain their views on the matter. In 175, the Minister has committed the same procedural irrationality in this matter. Stakeholders were not consulted on the ASO date. On 28 November 2024, they were informed that the deadline of 31 December would not be extended. On 5 December, they were simply told that the deadline would now be 31 March 2025. There was no consultation process in between. Stakeholders were never asked to comment on whether 31 March was a viable and reasonable date. Stakeholders were not even asked to comment on the Minister's plan to install STBs before 31 March. In the first place, this is because the plan did not exist before the decision to postpone was taken, a patent irrationality. But even after the decision to postpone, the Minister arranged a single call with stakeholders on 20 December for the reasons I discussed above, the meeting at various procedural irregularities. Chief among these was the Minister's failure to allow any comments on the preliminary plan before he decided to make that plan final. So, my Lord, if I could just pause there. The factual position is stated unequivocally. No prior notice of the new date of 31 March 2025. It was presented as a done deal and no consultation around that date. Now, if you look at the answer provided by the Minister, those fundamental underlying facts are not disputed. Indeed, their answer is an attempt at confession and avoidance. In their answer, which is to be found at 17.35 to 17.37, this is what they say. The contents of paragraph 174 are not applicable to this case. In this case, the applicants have always been aware of the deadline of 31 December 2024. The applicants themselves made a long list of written submissions to the government to postpone that date. The government considered their written submissions and indeed postponed that date. The applicants, and listen to the wording here, the applicants were not necessarily entitled to another round of consultation to fix a new postponement date, considering that they had, in a long list of written representations, expressed their views about their preference, which the government considered before arriving at the 31 March 2025 deadline. The contents of paragraph 175 are denied. I deny that the applicants were entitled to another round of consultation, considering the fact that they had already made a long list of written representations to the government, motivating for a postponement of the 31 December 2024 deadline. So, my Lord, there you have it. The factual foundation for this argument is respectfully absolutely clear. There was no prior notice of the new deadline, or the new ASO of 31 March, and there was no consultation with interested parties about that new date. And so, my Lord, the only question that remains for your Lordship is, well, what are the legal consequences of that? I have shown your Lordship that the answer to that question is respectfully beyond debate. The Constitutional Court has made absolutely clear that what is required is consultation on an actual date. And that's not simply, as it puts it, a mechanical process. The reason why the actual date is of such vital importance is because it enables both the decision maker, dare I say, and interested parties to make submissions on effectively how many people will be left behind. And that can only be done in relation to a particular specified date. Now, my Lord, when the Minister says in his answer, which I've just read to your Lordship, that ETV had made, and I use his word, a long list of submissions to government to postpone the date, and that the government did postpone the date, that misses the point respectfully entirely, both factually and legally. Factually, the letter to which reference is made there by the Minister, which is the letter of 1 December, was in respect of the ASO which was then set for 31 December. It was not, and it could never have been a response to the new unilaterally imposed deadline of 31 March, in respect of which nobody had prior notice and nobody had an opportunity to respond. So factually, there is no answer to our submissions, and legally, my Lord, the stance is plainly bad in light of the ETV judgment. So, my Lord, the specific requirements of consultation relating to the date of the ASO were simply not met. Now, my Lord, I have so far focused on the very specific requirements of consultation around the ASO date as laid down by the Constitutional Court. But of course, the requirements of proper consultation in general are indeed well known. And my Lord, we refer in this regard to your Lordship's judgment in Telkom versus ICASA, which make 2 points which resonate particularly powerfully with the present case. In the first instance, your Lordship held that where an organ of state, in that case it was ICASA, adopts a change of stance, or as your Lordship puts it, changes horses midstream, then in your Lordship's words, ICASA had a duty to apply the fundamental principles of hearing the other side and ensure that all interested parties were informed of the proposed change. My Lord, that didn't occur in this case. There was a fundamental change. There was a change of horses midstream. A new date was set. Nobody was informed of that. Nobody had an opportunity to make representations on that. And secondly, your Lordship held, and it's related to the first point, is that ICASA in that case was under a duty, and I quote your Lordship, to play open cards with the stakeholders. My Lord, once again, we are constrained to submit to your Lordship that that too did not occur in this particular case. Now, my Lord, those considerations which were identified by your Lordship, of course, apply with equal force to the present matter. And my Lord, can I just round off on this point, and it's the last submission I make on this topic, and it's this, is that the Minister actually fails to appreciate the function that is served by procedural fairness. He somehow thinks it's an act of benevolence. It is not. It is not simply a benevolent exercise in hearing people who are potentially affected by a pending decision. It is equally, and perhaps in the present context, more fundamentally concerned with good and accurate decision making. My Lord, we refer in this regard in paragraph 3.16 to the Constitutional Court in Joseph versus the City of Johannesburg, where the court quoted Hoekstra as follows, and it applies very powerfully here. There, Hoekstra said, procedural fairness is concerned with giving an opportunity to participate in the decisions that will affect them, and crucially, a chance of influencing the outcome of those decisions. Such participation is a safeguard that not only signals respect for the dignity and worth of the participants, but is also likely to improve the quality and rationality of administrative decision-making and to enhance its legitimacy. And it is that last point, my Lord, which respectfully the Minister simply fails to grasp. Is that had there been proper consultation, and I'm going to come to this in my next topic, the Minister would have been left in no doubt whatsoever that on his own statistics, well over 1 million people are going to be left in the dark if ASO is to take place on the 31st of March. But he didn't embark upon that necessary consultation. And he failed to have regard to what the Constitutional Court demanded of him in his capacity as the responsible minister. So what we are left with, my Lord, is a carbon copy repeat of the previous inadequacies in consultation. And we submit, my Lord, that the same consequences must follow. In this case, of course, all that your Lordship need to do is to come to a prima facie conclusion that there was the absence of the required consultation. My Lord, that concludes my penultimate topic. My last topic is to explain to your Lordship why the setting of the ASO at 31 March is irrational, on the basis that it simply cannot, on a number of bases, but specifically, it cannot achieve its intended purpose. My Lord, I see it's just on 11:15. Would this be a convenient time? Or quite happy to continue if your Lordship would wish.
Yes, we'll take an adjournment for 15 minutes.
Thank you.
I'll check the hour in 15 minutes. 15 minutes.
Yeah, we're not
Mela, lesi sizokwazi ukubamba lo angabamba yile. Lazi. Yo, Maria charge manje. Ngifuna ukwenza snacks. Maringaphumi ijulile.
March, nor was there any consultation on that date. So what I'm about to address, my Lord, is why the result is irrational, because of its failure to have regard to two of the critical questions which have to be factored into the determination of the ASO date. That is, the numbers of people who are going to be affected, and relatedly, the numbers of those persons who have set-top boxes and the backlog in the installation of those set-top boxes. So, my Lord, I address this topic in paragraph 4 of my references, and I start with the legal foundation for the argument, and once again, that is definitively established in the ETV judgment. And the first foundational principle is that the objective sought to be achieved is, and I quote from the judgment, the transition to digital television without causing millions of persons to lose access to television on the analog switch-off date. Now that is the stated purpose of digital migration. It is expressly articulated in the digital migration policy, and it is repeatedly set out in the ETV judgment. I've given your Lordship 3 references to paragraphs 63, 77 and 78. Let me take your Lordship to 77, where the court said, it cannot be said that the Minister's failure to adequately provide an opportunity for persons to be informed about the need to register before the deadline, and thus to obtain accurate information about households requiring STBs, is rationally connected to a successful migration process. Without obtaining and considering such information, the Minister was not in a position to determine an analog switch-off date that would mitigate the harm caused by such switch-off, which the Minister accepted was amongst the central goals of a successful migration process. So, my Lord, that is the object to be achieved. The second proposition is that steps must be taken to notify persons eligible for the receipt of STBs, that there would be, and again I quote from the Constitutional Court, the imminent loss of access to television on a set date and not a theoretical date in the future. That's what the judgment says at paragraph 67. And thirdly, a statement to the public of a need to register but without a deadline by which to register is insufficient. So, my Lord, in order to qualify as a rational decision regarding the ASO, there are two critical issues which had to be considered and addressed. The first, how many people will be left behind on the switch-off date, having regard to the fact that, as the Constitutional Court put it in paragraph 63, the objective sought to be achieved being the transition to digital television without causing millions of people to lose access to television on the switch-off date. And secondly, is the process of registration for STBs as well as their installation sufficient to ensure that millions of people will not lose access to television on the switch-off date? So let me turn to those two questions. And starting with arguably the most fundamental question in this case, and that is, how many people are going to be left in the dark if the ASO is to proceed on the 31st of March, and to consider that question in light of the state's repeated promise reiterated, ironically, in these proceedings that nobody will be left behind. Now, my Lord, I'm going to approach this on two bases.
And can I also expand the foundation you just laid?
Yes.
With reference to what I presume will be pursued strenuously by the first respondent, namely a suggestion in their heads that the applicants are hopping on these millions of people without providing any evidence, as they put it,
Yes.
of that fact. And putting the question in agreeing with you that it's a fundamental question to
What?
consider, because it seems to be, if I understand the papers correctly, playing on the numbers, saying the numbers are not what the applicants submit.
Yes. My Lord, I intend to address precisely that question immediately. And my Lord, I'm going to do it on two bases. I'm going to start with the minister's own figures. I'm going to start with the actual figures which he accepts. And I'll demonstrate to you what those numbers are. And I will show your Lordship in due course in a moment why in truth the numbers are much larger. But on the most conservative basis, the numbers are still massive. So let me start with that, my Lord, if I may. And I stress to your Lordship that I'm going to be, in the first instance, adopting the most conservative approach. Conservative in the sense of the lowest numbers that can possibly be regarded as being affected. And I need to tell your Lordship immediately that there are certain inconsistencies in the minister's evidence. Bear in mind, that's the approach I'm taking now. But the discrepancies are not of any significant magnitude, and I'll point those out to your Lordship as I go through. But Lord, I address these numbers in paragraph 4.3 of my heads. Let me start out with what the minister says on affidavit under oath. And as I stress, he's not particularly consistent. But in the first instance, this is the lowest number. He says, my Lord, and you'll find this in 4.3.1, that as of 21 February, says the minister, 391,513 households were registered for STBs but had not yet received them. That's 391,513 on the Statistics South Africa ratio of 3.2 persons per household. That translates into 1,250,841 people, 1.25 million people. Now that is the lowest figure that your Lordship will find on these papers. It's not the accurate figure, but it's the lowest. There is then the CENTEC presentation to Parliament on the 27th of February. Bear in mind, CENTEC is really at the coalface when it comes to the question of installation. CENTEC gave the figure as of 27 February in Parliament as 421,000 households. That translates into 1.347 million persons. And then at another place on the in the affidavit, the minister says that, and I quote, this is in 4.3.3, there are currently 447,000 households which remain to be supplied with government-sponsored STBs, and that translates into 1,430,400 people. And our learned friends in their heads of argument accept that that is indeed the number, 447,000 households, and I've given your lordship the reference in 4.3.3. So, my lord, one is talking now at the most conservative basis of something between 1.25 and 1.5 million people who are yet to receive the promised STBs on the minister's own version. Those are the minister's figures. Now, it's important to appreciate, my lord, that it is not the minister's case that those admittedly registered households will have STBs actually installed by 31 March. That would require an installation miracle, and there is not the remotest suggestion that such a miracle can possibly occur. And the minister candidly accepts that there will not be any miraculous rate of installation. In fact, his stance is that even those who have registered will only receive their set-top boxes, will only have them installed by the 31st of December this year. My lord, I give you 4 references to where the minister says as much in paragraph 4.4. So, my lord, it's actually not possible to know whether these 1.25 to 1.5 million people will receive their set-top boxes by year end. This is because in answer, the minister refers to a plan, but he's never disclosed that plan to the court or to the applicants. So this bald assertion, which I stress is exclusively within the knowledge of the minister, carries no evidential weight. Bald assertions, my lord, are as useless as bald denials. As the SCA has put it, my lord, this is not in my note. If your lordship could just take a note. The SCA said this in a case called A.M. Muller Group Limited versus The Gap. It's 2005, volume 6 of the South African Law Reports, page 568, Supreme Court of Appeal at paragraph 31. The court said affidavits in application proceedings must do more than make bald assertions. They must, in addition, provide the facts that support the allegations. So, your lordship is left in the dark as to what the plan is, and hence there is no factual justification for the imminent rights infringements which my learned friend Mr. Ferreira for MMA will deal with. But what we do know is that the minister told Parliament on 19 November last year, there he said that there were 469,370 households which remained without STBs despite having registered for them. And astoundingly, 90% of those households were registered over a year ago but had not yet received set-top boxes. That's in 4.6. So, my lord, just to be clear, what will happen on the state's version if ASO takes place on 31 March? Approximately 1.25 to 1.5 million people will be subjected to a television blackout. Those who will be so subjective are the poorest of the poor, who are entirely reliant on the state to assist them with set-top box installations, and the vast majority will be subject to that blackout until at least the end of the year. Now, my lord, A critical feature of this entire process was, of course, the promise made that no qualifying household would be left behind. And the obvious implication of this promise is that when switch-off occurs, qualifying households will not be left in the dark. In other words, on the date of the switch-off, they will continue to receive television broadcasts via set-top boxes, and that is indeed entirely consistent also with the Constitutional Court's finding on this issue. I give your lordships the references in 4.8, but in the first instance, the court held, and I quote, the STB registration process and the deadline for registration form part of the process leading up to the analog switch-off, said that at paragraph 46. And second, it held that the duty of consultation would need to address critical issues before the ASO, including, and I quote, the number of persons who qualify to receive STBs, who would like to register for STBs before the analog switch-off date, and how long it would take at the current rate of installation for all households that wish to register to receive STBs to be supplied with such. Instead, my lord, in a regrettable choice of language, the minister repeatedly says that the process cannot be held to ransom. That's the word he uses, by so-called latecomers. That approach, my lord, we submit, simply turns a blind eye to the state's inactivity between August 2023 to October 2024. And we give your lordship the statistics in paragraph 4.10. Only 45,450 set-top boxes were installed between August 2023 to October 2024. Between August and December 2024, the department only managed to install 15,740 STBs, that's roughly 3,000 a month. And even though the state knew that in August 2024, well over 400,000 households required STBs, that is close to 1.3 million people, before December 2024, it installed only 61,000 STBs in 18 months. So, my lord, let us be clear as to what is now taking place. On the minister's own version, he is deliberately embarking on a process which he knows will not achieve the objective identified by the Constitutional Court to transition to digital television without causing millions of persons to lose access to television on the analog switch-off date. That is the Constitutional Court's words in paragraph 63. And that, my lord, on the most conservative basis, is per se irrational. And secondly, my learned friend Mr. Ferreira will address this, it is an unjustifiable limitation of rights. And of course, it is the state that bears the burden of justification. But, my lord, I said to your lordship I was going to address this on two bases. First, on the most conservative possible basis, but secondly, on what the facts in truth demonstrate. In truth, my lord, the situation is far more serious than the minister states. As we demonstrate, my lord, at the current actual rate of installation and on the somewhat radical assumption that there will be no further delays, 978,608 people, close to 1 million people, in registered households will be left without access to television at the end of the year. My Lord, I give you that in 4.13. But let me pause there, my Lord. The minister undertook to provide the court with an update on installation. I think I give your lordship the reference in 4.13. Anyhow, it's in the answering affidavit at paragraph 13.8 at 010-82. Is that in 4.13? I'm just checking if your lordship has the reference. Answering. Anyhow, my lord, that was a promise made by the minister. Now, my learned friend has informed me this morning that there is apparently an affidavit which is in the process of being commissioned, and I'm authorized by my learned friend to tell your lordship that the figure of registered but as yet uninstalled STBs is 405,000 households. That, my lord, is 1.3 million people. And my lord, I've so far confined myself to the position of registered households. But if one considers the position of indigent but as yet unregistered households, the position is respectfully nothing short of catastrophic. We have presented to your lordship the statistics compiled by the Broadcast Research Council of South Africa, which I stress, my lord, despite the repeated denials in my learned friend's heads of argument, the very point to which your lordship alluded, those statistics are not disputed by the minister. And I'm going to show your lordship the references in a moment. That evidence reflects that approximately 28% of the population, that translates into close to 14 million people, 13.8 million people, rely exclusively on analog television. And the minister's constant refrain is that there is no evidence that millions of people will be subjected to this television blackout come 31 May. Those claims, my lord, are nothing short of startling, given the fact that the minister did not dispute those statistics. And indeed, my lord, this is not even a case of an evidential omission. In relation to the statistics put up by the applicants, the specific response by the minister to the paragraphs in question is that the contents of these paragraphs, I quote, are not in dispute. That's at paragraph 4.15. So, my lord, your lordship was right, respectfully, to draw my attention to the countless denials in our learned friends' heads of argument. But, my lord, those denials simply ignore the evidence. The statistics that are put up are admitted by the minister. So I accept, my lord, that those statistics relate to indigent but unregistered households. But in answer to your lordship's question as to the actual number who will be affected, it is in the magnitude of multiple millions. But, my lord, the minister somewhat callously says that those people, the indigent but unregistered, are not his concern. He says that he only has obligations to those who have registered for STBs, but even in relation to those, he turns a blind eye to the fact that come 31 March, on his version, if one takes the apparently forthcoming affidavit, which puts the figure at 405,000 households, there will be 1.3 million people left in the dark. So, my Lord, it becomes important to appreciate what has in fact occurred in relation to registration for STBs since the ETV judgment. After the ETB judgment, a new STB cut-off registration date was set at 30 September 2022. I give your Lordship the references in 4.17. And throughout his affidavit, the Minister adamantly relies upon that cut-off date for registration, 30 September 2022, as being central to his obligations to indigent households to whom the state's promise relates, and he therefore discounts all those who registered after 30 September 2022. That is the Minister's stance. But, my Lord, I'm afraid it suffers from a fatal defect, one entirely overlooked, respectfully, by our learned friend in his heads of argument. It turns out that the Minister is grievously mistaken, because the evidence establishes that the government in fact decided to extend the date of registration beyond 30 September 2022, yet in a fatal about-face, the Minister now says that only those registered by 30 September are the beneficiaries of the state's promises. So let me tell you what the position is, first of all, at the level of fact. Now, I give your Lordship the reference at 4.20.1. On 19 November 2024, the Minister told Parliament that he and stakeholders had agreed to extend the registration deadline to September 2024. Now, my Lord, I've given your Lordship the reference. It's part of the slide presentation, which your Lordship will find at 002-169. You have the reference. Your Lordship doesn't have to go to it, because I'll tell you what it says. It says, agreement reached by BDM stakeholders during a workshop held on 14 and 15 August 2023 to extend registration timeline to 30 September 2024, and then it follows, allow 2 months, October and November 2024, and listen to this wording, my Lord, to wind up installations. So the evidence is unequivocal. Our learned friends and the Minister are simply mistaken in believing that the critical date is 30 September 2022. It was extended by agreement to 31 September 2024. And as the presentation to Parliament indicates, the intention is by November 2024 to wind up installations. Now, my Lord, that can only have one clear and respectfully logical meaning. If one has regard to the object sought to be achieved by digital migration, and that is to ensure that people are not left behind, if one has regard to the promise made by the state, even on the most narrow and conservative basis, that those who have been registered will not be left behind, what your Lordship is faced with, unmistakably, is a deliberate endeavour to embark upon a digital switch-off which will leave behind, at a minimum, 1.3 million people on the Minister's own version. That is the simple, stark and inescapable fact. My Lord, secondly, and we point this out in 4.20.2, public announcements and awareness campaigns from 2022 onwards informed the public that registrations remained open for set-top box installations, and by April 2024, the public awareness campaigns made no mention of the now rigidly adhered to but outdated deadline of 30 September 2022. The Minister, thirdly, has never previously, that is before filing his present affidavit, sought to justify the ASO date unilaterally announced by Cabinet as 31 March by reference to the cut-off date for registration as being 30 September 2022. That justification is never foreshadowed in any of the correspondence, nor in any of the Minister's presentations. And, my Lord, respectfully, the reason is obvious. The registration cut-off date was extended to September 2024, as the Minister, in fact, told Parliament on the 19th of November. Fourthly, my Lord, there was no consultation with stakeholders on this fundamental shift. It gets back to your Lordship's judgment in the Telkom and ICASA matter. And likewise, as the Constitutional Court judgment in ETV makes clear, the purpose of that consultation had to be directed at determining the number of persons who qualify to receive STBs and who would like to register for them before the ASO. And obviously, my Lord, and as we point out in our heads, if there is a change in policy, which is permissible within limits, but where that does occur, it triggers the obligation of a hearing. And lastly, my Lord, and this is important, we are constrained to submit to your Lordship that the Minister has not been candid about this change with either the court or the public. And your Lordship will take a dim view of the Minister's approach, having regard to the fact that, as your Lordship, I'm sure, knows, the state has a higher duty in litigation to be candid with the court. Could I ask your Lordship to add one reference to 4.20.5 of my note? It's the case of the Public Protector versus the South African Reserve Bank, and it's reported in 2019, volume 6 of the South African Law Reports, page 253, Constitutional Court. And can I just draw your Lordship's attention to what the court said precisely on this kind of issue at paragraphs 155 to 156. The court said this: the public protector falls into the category of a public litigant. A higher duty is imposed on public litigants as the Constitution's principal agents to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. The need to hold government to the pain and duty of proper court process is sourced in the Constitution itself. This is because the Constitution regulates all public power, and public officials are required to act in accordance with the law and the Constitution. And then in 156, in a concurring judgment in Matatiele Municipality, Sachs J. held that the constitutional injunction for our democratic government to be accountable, responsive, and open implies that candor is required from government officials when they are before the courts. This is also consistent with section 165(4) of the Constitution, which requires organs of state to assist and protect the courts in order to ensure that they are effective. Now, my Lord, I am constrained to submit that the Minister has fallen short of those obligations in litigation as an organ of state. What is perhaps to our learned friend's credit, is that despite this obfuscation, our learned friends accept, and I assume do so on the minister's behalf, that, and I quote from our learned friends' heads, the reason why the government did not close the registration process is to ensure that no qualifying household is left behind. That's as our learned friends put it in their heads. Well, precisely, my lord. And that is because, as it was put by the Constitutional Court, the STB registration process and the deadline for registration form part of the process leading up to the analogue switch-off. And this is in turn what the digital migration policy and the state promised. The only way that no qualifying household will be left behind is to install STBs before the ASO. That, it is common cause, cannot and will not happen by 31 March this year. My lord, we therefore submit that there is a substantial case for interim relief, far stronger, we would respectfully submit, than the relatively lower standard of a prima facie case. And we submit that your lordship should grant relief in the terms prayed for. We would respectfully submit it justifies the costs of 3 counsel. We don't suggest any more than that, and we would so move, your lordship. Lord, those are my submissions. Thank you, my lord. My lord, I said we would change places with my learned friend for MMA. If your lordship will just give 1 moment for us to do that.
Thank you, my lord. My lord, I will be acutely careful not to repeat any of the submissions which have already been made by Mr. Marcus. We propose with a slightly different emphasis, because the court will be aware that my clients are 2 non-governmental organizations who act in the public interest to protect the rights of the public. And we will be very careful not to repeat any of the submissions, but to focus our submissions on the impact of the proposed premature analog switch-off date on those rights of the public. And with the court's leave, we will address that issue under the following 4 headings. Firstly, the question of the limitation of fundamental rights that will occur if analog switch-off occurs prematurely. Secondly, some brief supplementary submissions on the question of unconscionable state conduct, the promise that was made by the minister. Thirdly, the issue of consultation, insofar as it relates to my clients in particular. And finally, the elements of an interim interdict, which we submit are plainly satisfied in this matter. The third was the question of consultation, insofar as it relates to my clients. And the fourth is the satisfaction of the requirements for interim interdictory relief. My lord, if I may move directly to the first point, the question of limitation of fundamental rights. Our learned friends for ETV have spent some time explaining to my Lord why on the facts there are indeed millions of affected people. We would only emphasize that even on the Minister's version, there are at least 1.3 million individuals who will be plunged into a television blackout as a result of the ASO date of 31 March 2025. That is because the Minister's, as Mr. Marcus said, lowball figure is some 391,513 households, which must be multiplied by 3.2 individuals, according to Statistics South Africa, which gives you roughly 1.3 million people. My Lord, that is the lowest possible figure of people who will be plunged into television blackout. Centec actually told Parliament that it will be about 100,000 more in their presentation to Parliament of a few days ago, as Mr. Marcus pointed out, and we would only emphasize in addition that there is a further cause for alarm from that Centec presentation, because what you see from it, it is at page 011-95, is that in this rush to get to a switch-off date, Centec is now only installing set-top boxes in 4 provinces. They have left out of account the other 5 provinces because they erroneously think that analog switch-off has already happened in those provinces. But they are wrong about that. It is only the SABC which has turned off its analog transmitters in those other 5 provinces. ETV continues to broadcast on analog in those provinces. But Centec and the Minister are trying to get to a date as soon as possible, so they're rushing. So they're focusing all of their resources on these 4 provinces, and they're leaving the other 5 out of account entirely. And we would simply wish to emphasize that that severely exacerbates the harm that will be caused, because it means that all of this progress which is being made and the updates which our learned friends are going to place before court is progress which is being made only in 4 provinces, but 5 provinces are being ignored entirely. And as Mr. Marcus has submitted, we have no idea how long these 1.3 million people will be left without television for, because the Minister either does not know or has not told this court how long that blackout will last for. So at least it's 1.3 million people are going to lose access to television for an indeterminate period of time. That is the first fact, which is common cause. This
there's one thing that I struggle to understand. If Centec is the implementing agent on behalf of government or the minister, and they commit an error regarding installations by suggesting that there's been a switch off already in the other. Now, I don't understand how that misunderstanding can happen, or that error can be committed, because Centec, more than anybody, if my understanding is correct, is the one agency that should know exactly the facts, the correct facts, where switch off has occurred and where it has not, because it is the implementing agent.
Yes, I think the confusion has arisen, my Lord, because both the Minister and Centec, it is correct that the SABC has switched off its analog transmitters in those provinces. And I think the confusion arose because they thought that there had been a universal switch off. But as I understand from the papers, that is an error of fact, because in fact ETV continues to broadcast on analog in those provinces. I can't account for the error other than to say that it appears to have arisen from the fact that the SABC has in fact turned off in those provinces.
But even if SABC has turned off, wouldn't Centec be the agent, or is it not involved?
No, my lord, I actually don't know the answer to what Centec's involvement is in actually turning off the transmitters. I would have to have a look.
Yes. Well, my misunderstanding, if it is, arises because SABC is a public broadcaster.
Yes.
Where I would imagine the minister and Centec would have the correct facts and so on.
Yes.
But if you're no instructions,
No, my lord, and I'll just ask my junior to get the references to the pleadings where ETV makes the allegation, and as I understand, it's not disputed that it continues to broadcast in those provinces. So, but my lord, our submission was simply that it exacerbates the harm, and it means that the period of blackout is going to be longer because those individuals in those provinces are not currently getting installations at all. The other form of limitation which I wanted to draw the court's attention to, which has not been addressed at all by the minister, is the massive harm which will be inflicted on broadcasters. When I say broadcasters, I mean in addition to ETV, which has made its own case, the SABC and the 6 community broadcasters, which are all reliant upon analog broadcast. My client is concerned about a rich and vibrant ecosystem of expression in which a range of different views and a variety of sources of different information can be received by the public. And what my client says, which is undisputed in the answering affidavit, it's from pages 003-13 to 003-21, and it's paragraphs 34 to 54, is that if you switch off analog transmission before a sufficient number of audience members have managed to migrate to be able to receive digital transmission, you will devastate the operations of these broadcasters. And the mechanism is quite simple, because if you switch off analog broadcasters while those audience members are not able to receive digital, that means that your advertising revenue is going to fall through the floor. And so what my client says at paragraph 54 of the answering affidavit is he says, if analog free-to-air services were to be switched off, free-to-air television's audiences on any platform would drop from a total of 54% of the population, taking into account current analog DTT and DTH, to only 26% of the population, leaving 28% entirely without access to television services of any kind. So the effects are twofold in relation to the value of expression. Number one, we all agree 1.3 million people are going to suddenly lose access to television completely. And number two, the SABC and the 6 community broadcasters are going to be commercially devastated because their audience is going to be cut in half overnight. That is undisputed at the level of fact. My Lord, the reference to the pleadings where ETV makes clear that it continues to broadcast in analog in these 5 provinces is page 002-16 at paragraph 47. So, my Lord, those 2 facts we submit constitute a clear limitation of expression rights, because we know from the authorities which we've cited in our heads of argument that expression is not protected just so that people like ETV and the SABC have the entitlement to say things and to express themselves. The purpose of freedom of expression is actually for the public to be able to receive ideas. That's where the value lies, in the receipt of ideas by members of the public, to allow them to participate in the marketplace of ideas. That is, the Constitutional Court has said that on a number of occasions, and we've set that out in our heads of argument at paragraphs 8 to 9. And the Constitutional Court and the SCA have recognized that television is the primary medium for receiving information in our democracy, in particular for poor and indigent households where literacy levels are lower. And access to television is necessary to allow meaningful participation in the marketplace of ideas. And we know, my Lord, that it is common cause that the people we are talking about now are indigent households who cannot afford to migrate themselves to digital. They cannot afford to buy it. Even if there were set-top boxes available in the shops, which we know from the pleadings there aren't, or aren't enough of, even if there were, these are people who can't afford to make that migration, and they can't afford to get even the cheapest DSTV package with no sport, but which will at least allow you to decode digital television. So we know that the impact is disproportionately going to harm those who are most vulnerable and who are already most excluded from our public discourse. And we say that is an obvious limitation of the right to free expression. Secondly, my Lord, it is also what our courts have referred to as a retrogressive measure. Because these people currently, and for the last few decades, have access to free-to-air television. The state is taking an existing access to a fundamental right, and it is reducing the extent of protection by taking away that access. And our courts have held time and again that that constitutes a retrogressive measure. Retrogressive because we achieve a certain level of rights protection, and then the state decides to roll that measure back and remove that access. And, my Lord, if I can just refer you to the two judgments we refer to in our heads of argument. The first is the Juma Musjid case, where the Constitutional Court dealt with the case where a private property owner took steps to evict a public school because the Department of Education had failed to pay the rent on that property. And the Constitutional Court held that the department there had breached its negative duty not to interfere with existing access, and it said that the negative duty was breached when the state takes measures to diminish existing protection. That's paragraph 58 of the judgment. It's on case lines at page 020-32. And so this is plainly a retrogressive measure because there is existing protection of expression rights, and the analog switch-off is going to take that away from at least 1.3 million people. And the second judgment, my Lord, is the Grootboom judgment, where at paragraph, it's at page 020-73 of case lines, and it is paragraph 45 of Grootboom. What the Constitutional Court said, that was in the context of socioeconomic rights, but it said any such retrogressive measure must be, requires careful consideration and must be justified by reference to all the rights. In that case, it was in the Covenant of International Rights. But we submit in this case, because you're dealing with rights in the Bill of Rights, what is required is the most careful justification in terms of Section 36 of the Constitution. So, rights are going to be limited. It's going to be a retrogressive measure. What that means is that if it's going to pass constitutional muster, there must be a justification in terms of Section 36. Mr. Marcus already pointed the court to the authority, which is very clear that the onus to put up the facts in justification of any such measure lies upon the state, and in this case the minister, and they must put up either the factual or policy considerations which would justify that limitation. That's the Moise judgment and the Nikro judgment, which we've cited in our heads of argument. Now, my Lord, with respect to the minister's case on this score, we say he really says only two things which would justify this limitation of fundamental rights. The first is that he says that digital migration has already been long delayed, and we cannot continue to be held hostage by those who haven't bothered to register themselves to be migrated. They haven't taken steps to protect their own access to television, and so it's not for the state to hold their hands and carry them along into digital migration. Now, in relation to that point, my Lord, we say firstly that the 1.3 million we're talking about have registered. The 1.3 million are people who, on the minister's version, have registered for a set-top box, and on the minister's version, are not going to get a set-top box before they lose access to television. And secondly, my lord, we know that the terrible delays in this case are due to the minister's department and Centec. It is what a member of the Parliamentary Portfolio Committee aptly described as poor project management. It's poor supply chain management, it's insufficient procurement of equipment, it's delay after delay after delay, long periods of inactivity on the part of the state. It's a story that has unfortunately become all too familiar in South Africa, where our state capacity to do what it wishes or has to do simply lets us down. And so you can't blame the delay on anyone other than the minister's department. That's the first justification, which we say is no good. The second is that we get this allegation that dual illumination is expensive, and the state has decided to stop paying for that expense. And the minister says it's cost 1.3 billion rand, and government has taken a policy decision that it no longer wishes to incur that cost. Now, my lord, in relation to that allegation, we have the following submissions. The first is that that number of 1.3 billion rand is completely unsubstantiated by any objective evidence. The minister just says it's cost 1.3 billion rand. It is also disregards the fact that that was the cost over the entirety of the previous decade of dual illumination. And the minister makes no effort to tell the court what it costs on a month-to-month basis now. And he also ignores the fact that the broadcasters themselves are carrying a significant part of that cost, which ETV makes clear in its replying affidavit at paragraph 54. So we submit, my lord, that that bare allegation does not come anywhere close to discharging the evidentiary onus which the minister bears in this case. And my lord, we make that submission in particular in relation to the submission that the cost is too much, in reliance on the SCA judgment in the Basic Education for All case, which we referred to in some detail in our heads of argument. It's an SCA judgment. I would simply commend to my lord to read that case, because when I was preparing to make my submissions and I reread that judgment, what strikes one is that the degree of similarity between the facts in that case and the attempted defense by the Department of Education, and the facts in this case and the defense which is put up by this minister. Because that was a case where there was a failure to provide textbooks to learners in the Limpopo province. It was established that those learners were overwhelmingly amongst the most vulnerable. They were overwhelmingly poor and black learners. The department had decided to change curriculum, and so there were practical difficulties which arose because they were running two curricula at the same time, almost a dual illumination period when it comes to curricula. And government simply failed to effectively fulfill its promise. It had promised to deliver these textbooks, and for a range of reasons, it didn't manage to deliver them to all of the schools. There was again, as there is in this case, a dispute about the numbers of affected pupils, but it came down to about 2.3% of students in the Limpopo province who hadn't received their textbooks. That's at paragraph 28 of the SCA judgment. There again, it was NGOs like my clients who litigated to try to assist, to force government to do what it had to do for those pupils. And there again, it was because the department's plan had failed that the limitation of constitutional rights came about. And again, the Department of Education blamed the schools. They said, you schools have failed to register, you didn't participate properly in our registration process, and so that's why we didn't get there. And again, as here, the department told the court it didn't have funds available, and if the court told it that it had to provide these textbooks, it would be infringing on the separation of powers. And so it was essentially the identical problem, the identical defense. And what the SCA did at paragraphs 36 to 43, my lord, is that it rejected that defense by the Department of Basic Education. It held that a violation of basic rights could only be justified under Section 36. It held that the Department of Basic Education had made a commitment, a public commitment, to provide those textbooks, and in granting the court order, the court would not be infringing separation of powers, but only holding it to its own public commitment. And it held, my lord, like here, that the Department of Education's logistical efforts to deliver textbooks was inadequate and woeful, were the words the SCA used to describe it at paragraph 43. It said there had been no proper planning, there had been no substantiated evidence that the department was unable to procure funds to deliver these textbooks, and as a result, the court set aside the defense based on a lack of budget as fallacious and contrived, and made the order that there was a breach of the Constitution and that the state would be held to comply with its own duties, with its own public promises. So, my lord, we have made submissions in our heads of argument, and I won't repeat them, that there is a repeated public promise by the minister not to leave anyone behind, and we would simply point out, my lord, that that promise is repeated again in the answering affidavit. It's in paragraph 3.3.4, where the minister repeats that promise. He says, we promise not to leave anyone behind when we do analog switch-off, but we know from the common course facts that he will leave 1.3 million people behind if it is switched off on the 31st of March. And that breaches the principle set out in KZN Joint Liaison and Pretoria, which we have set out in our heads of argument at paragraph 27. It would be unconscionable state conduct to allow the minister to breach his own seriously made promise that no one will be plunged into television blackout as a result of the date of analog switch-off. So, my lord, that concludes our submissions on the public promise. If I may now briefly move on to the consultation point. We don't repeat what our learned friends have said about the consultation having to relate to a particular date. We entirely agree with those submissions, and we agree that it is common cause that that never happened. It was simply a fait accompli that the December 2025 date was pushed back to December 24 was pushed back to March 25 without any consultation about the March 25 date. All that we wish to add, my lord, is that it's even worse in relation to my clients, because the Constitutional Court, in its judgment at paragraph 52, made expressly clear that any consultation process leading to a determination of date of ASO had to include MMA and SOS. They were interested and affected parties, and they had to be included in those consultations. And it is common cause on these papers that my clients were excluded from those consultations. That is set out in detail in our heads of argument at paragraph 34. And the chronology there, my lord, is that my clients didn't sit back and wait. They repeatedly wrote to the minister asking to be involved and asking to be consulted. And they started, as we say in paragraph 34.1 of the heads of argument, on the 9th of March 2023, writing for a request for a meeting and a consultation. The minister did not respond. On the 20th of March 2023, they wrote again, requesting a response. The minister did not respond. And now, my lord, at paragraph 34.3 of the heads of argument, this is maybe the most important factual allegation which is not contested in relation to my client's exclusion. Before promulgating 31 December 2024 as the ASO date on 14 June 2023, the minister gave MMA and SOS no advance notice and no opportunity to make representations. That is paragraph 16 of the Bird affidavit at page 003-7, and it is not addressed in answer, my lord. So then we've got this date of 31 December that my clients were never consulted on. My clients then start writing to the minister, 16 August 2023, 28 November 2023, repeatedly requesting to be consulted. And what you see again and again is there's no response until the 20th of December 2023, when the minister writes back and he says there is no need to consult anymore because we have already consulted extensively on the ASO. That, my lord, you find at page 003-37. And then, my lord, there were these meetings with broadcasters in the Broadcast Digital Migration Committee, which MMA and SOS were not invited to. We don't say that those meetings constituted an adequate consultation, because as Mr. Marcus has explained, those meetings never concerned a particular date of switch-off. But even though it was inadequate in relation to the broadcasters, it was even worse in relation to M&A and SOS because they were excluded despite their repeated attempts to be included. And we then accelerated towards the end of December last year. And again, there is just, despite these attempts, repeated attempts by my clients to be consulted, they get ignored. And then they are finally told on the 5th of December, we have now decided to push the date back to 31 March 2025 without any consultation about that date. And so throughout that time, my lord, yes.
The minister said we do not need to consult as we've already consulted. How do you understand that? Was it a reference to the June consultation, June 23? What consultations was the minister referring to? In your understanding of that response?
My lord, if the court goes to the letter, it's at page 003-37. And one has to read paragraph 4 of that letter in particular. And what the minister says is, he notes that my clients are concerned that it has directed correspondence to our client regarding a matter of national interest regarding the ASO. The ASO has already been a subject of lengthy litigation and a constitutional decision. Your client directed correspondence to our client in order to avoid further litigation regarding ASO. And it is crucial that the issue of availability and installation of set-top boxes are dealt with, and your client requested a further urgent meeting. And then at paragraph 5, our client is at a loss in an attempt to comprehend what your client's letter under reply is intending to convey, except for a threat of litigation in the event our client fails to meet with your client. And then here at paragraph 36, that being said, paragraph 6, that being said, as far back as 6 March 2023, our client directed a letter to your client addressing the very same issues, a copy of which is attached. And then he says on 16 June, as you will note from the attached report of June 2023, our client has already consulted extensively on the ASO. So what is being referred back to is the process that my lord raised with Mr. Marcus, the June 2023 process. And what we submit is that that process was A, inadequate because it didn't relate to a particular date, and B, my clients did not participate in that process because they were excluded despite repeatedly asking to be included.
Yes, that was going to be my next question. You participated, I wasn't sure.
No, my lord, and that's why I referred to paragraph 34.3 of our heads and paragraph 16 of the affidavit of Mr. Bird. And none of the allegations in Mr. Bird's affidavit are responded to by the minister at all. I don't know if whoever was drafting the papers just missed the fact that there was an affidavit, but there's no ad seriatim, there's no response thematically, they're just not addressed. And so those must be taken to be common cause.
Well, I do not want to belabor the point by asking whether you did point out to the minister that in fact what you referring to we were excluded from that process, so you haven't consulted.
Yes.
But in light of the fact that it's common cause, it seems there was
Yes, my lord, the one thing I can assure you of is that the letters written on behalf of my client made that point repeatedly. And they are annexures WB1, WB2, WB3 to the correspondence and the preceding annexures. And what you will see is that from 9 March 2023, my attorneys were writing to the Minister on behalf of my clients, making submissions and pointing out and asking to be included and consulted with, and pointing out that they had not yet been included and consulted with. And in respect of the bulk of those letters, there was simply no response. So, my lord, I'm now on to the final point, the elements of interim relief which are satisfied. We say, following from that consultation point, in relation to the balance of convenience, that we expect that our learned friends will tell the court that because this is government conduct, to get an interim interdict, you need to meet the heightened standard which the Constitutional Court set in the outer judgment. You have to show the clearest of cases of illegality. We submit with respect, following from the point about inadequate consultation, that one could hardly get a clearer case, because what you have is a Constitutional Court decision which says you have to do A, B, and C in order to take this decision lawfully. You have to consult with MMA and SOS, and you have to consult with them about the date that you are contemplating. And then it's common cause on the facts that that doesn't happen. And so this is the clearest of cases. You've got a Constitutional Court roadmap which was not complied with. So we submit that outer does not count against the relief that my clients seek. In relation to the prima facie right, the rights that we say will be harmed in the interim, because the court will be aware that to grant interim relief you have to conclude that there are rights which would be harmed between now and the Part B review if the interim relief is not granted. And we submit that is manifestly satisfied, because there will be a television blackout for at least 1.3 million people, and that will harm their right to receive information, and that will be an irreparable harm to their rights of freedom of expression. There will be the right to have the promise not to be left behind fulfilled, which will be breached. And there will be the right of my clients and the public to a lawful process of consultation in accordance with the Constitutional Court judgment, all of which, if there is no interim relief granted, will be irreparably harmed in the interim period. And then, of course, there are obvious prospects of success in the review. So we say the prima facie right element has clearly been established.
Yes. In saying it will be irreparably harmed by the blackout, as against the minister's promise to rectify that by December 2025, does that say anything?
No, my lord, because you will then have a 9-month period of information darkness, which can't be remedied by switching broadcast, which can't be remedied by having a set-top box installed in December, because then you have then gone through 9 months of no information. That's why I say it's irreparable.
So and then you address the prospects of success.
Prospects of success in the review, which the Constitutional Court in the informal traders case has said is one ground upon which one establishes a prima facie right. And it's not just the right to review, of course, because if Analogue Switch-off happens in 10 days' time, then what is the point of reviewing the decision to set the 31st of March 2025 as the date? The Minister will, by turning off the transmitters, render the Part B of this case moot, because there'll be no practical effect if the Part B succeeds. It's not as if the court will then tell, the court could conceivably say, Minister, your decision to set the date was unlawful. We know you switched off anyway. You are now ordered to turn those back on. But by that time, firstly, the harm will have been done. And secondly, the horse will have bolted. We'll be however many months down the line. And all those people who have been unable to migrate will have been sitting in television darkness for that time. And things will have moved forward. So the review will be practically meaningless. And, my Lord, may I say, in relation to the 31 December 2025 date, we don't accept that it will be done by that date. There's no evidence that it will be. If you look at Centec's historical rates of installation, that looks extremely unlikely because it's been bedeviled by delay after delay after delay, long periods where they were installing only 3,000 a month. And so if the past track record is the basis of thinking it's going to be done by the end of December, it's simply unrealistic. And finally, my Lord, I've addressed the question of the balance of convenience under the heading of the outer case. We say in reliance on basic education for all, there is no separation of powers harm because you are holding government to its own public promise and its own policy. And so as in basic education for all, the question of separation of powers harm does not count against our relief. And we submit, my Lord, finally, that there is no serious suggestion of any alternative remedy that could cater for the 1.3 million people during the interim period, or which could remedy the commercial harm which will be inflicted upon the SABC and the other community broadcasters. My Lord, we would also ask for our costs to follow the result. We submit that costs of 2 council on C scale would be appropriate in this matter.
May it please you, we have suggested to a lead counsel for the applicants that we answer both cases tomorrow morning and that they can reply after that. There's also an issue which has come to my attention about the affidavit that Mr. Marcus told you was going to be filed on behalf of Sanchez about the remaining numbers of qualifying beneficiaries who must still get set-top boxes. It is an issue that requires that I consult with both the first respondent and Sanchez. That affidavit has not yet been filed, but importantly, it seems to suggest that the factual position which I communicated to Mr. Marcus this morning, and I think yesterday as well, may actually be different. So, may actually be different. So it's something that I do need to consult on and get an understanding of what the correct position is and what caused the change. Because it is an issue that I'm sure is going to reply. It's going to arise in reply, so I will need to deal with it. So on that basis, we ask that we respond to the applicant's case in the morning tomorrow, and then the applicants can reply shortly after that. I don't expect that I will be more than an hour and a half in my main address. That's it, please.
Maybe I need to hear from the applicants.
That's it, please.
Lord, I didn't quite have the same understanding as my learned friend. I understood that the affidavit was simply awaiting commissioning, and hence I conveyed to your Lordship with my learned friend's approval the number of 405,000 households. So I'm a little bit in the dark about that, and dare I say, my Lord, This is not just the 11th hour, this is more than the 11th hour. That said, my Lord, we are in your Lordship's hands. There is an alternative, and that is that my learned friend does his answer, and it's indeed possible we could finish today. But I leave it entirely to your Lordship. He could answer now. If there is an affidavit overnight, he could deal with that in the morning. And but I really am bewildered by what I'm being now told.
Yes, well, I have requested your response because if it's about what I call the play on the numbers, you've already made your submission that your conservative view relies on the numbers presented by the minister himself. But you are saying, well, moving from that, there could be more. There are more than just the number. But you are saying, what the minister says, it's millions of people on that. And you also referred to the BRC information, which increases the numbers. Now, if that affidavit is available, it's a question of, well, are there more or are there less? But it doesn't make a difference to the case that you present. So, is it that critical that we do not proceed?
It's in our submission, it's not that critical, my Lord. On any basis whatsoever, the numbers are massive. And but I leave it to your Lordship. It seems we are in the urgent court. It's your Lordship's time, which is also at issue. And we will do as your Lordship directs.
Yes, I asked this before you sit down with this agency, yes, which is agreed between the parties. I do not make a finding in that. But also the consideration of the matter by this court and giving a judgment between now and in 10 days' time is a matter to be considered also. So any delay that pretends that we have all the time so we can be leisurely about it is not just suggested by the facts themselves, but also the practicalities of coming out with a finding, which is what this court is also concerned with. Maybe the parties not because they've done their part, but it should be a serious reason that delays us and causes an inconvenience in deciding.
And Lord, we are acutely aware of your Lordship's position. And that is why I'm hesitant to agree to my learned friend's suggestion. That the farthest we will go is to say that it is not ideal, but we leave it in your Lordship's hand.
Yes, thank you.
Well, I don't know if Mr. Ferreira wants to comment on that.
I'm sorry, Lord, we are also in the court's hands. It does seem to us that there are issues which have nothing to do with the affidavit, which could productively be dealt with in this afternoon session. But we take it no further than that.
Yes.
Please, sorry, if I can just reply. My Lord, it's not only just a question of the affidavit, but it's also about how we're going to present our argument in terms of structure and cross-referencing to the documents to which you have been referred. Mr. Marcus is right when he says that what I'm conveying to the court now is not consistent with his understanding. But that is exactly the reason why it is necessary that we be given an opportunity to consult with both Santec and the first respondent to understand what has now led to the change that I'm referring to. I think it is only fair. There isn't going to be a delay that creates a further problems for the court, because we sat down for 2 days, today and tomorrow, and we will finish the case tomorrow. There's absolutely no reason why the case should not be concluded by tomorrow. As I said, I estimate that I'll be an hour and a half to an hour and 45 minutes, and then replies can come shortly after that, and then this case will be done by tomorrow as originally planned.
But Mr. Consul, the reference document, argument that was presented this morning does not present a case that the respondent would not be aware of.
Correct.
He has merely tried to fine-tune and perhaps make it easy even for the court to, along with his submissions this morning, be able to reference the documents and to reference the judgments that are referred to and so on. But it's not anything new.
No, we accept, yes. But what we're saying, we want to then structure our response along the lines that is presented in that document. It will be beneficial and of use to the court if we don't jump around the papers, but we go chronologically in the manner in which the applicants have done their case. So we submit, my lord, that again, this is not going to delay the finalization of the case. We already sat down for 2 days.
Yes. Because the last thing that the court wants to do is to inconvenience any party in presenting its case. Purely because maybe the court wants to rush and finish the hearing of this case in order to get on with the weight of the submissions and the evidence. I'd be reluctant to do that, to say, just get on with it, and this is an urgent matter. And yes, it is correct that the matter is set out for approval. And I hear your submission about the certainty that the matter will conclude on the allocated dates or the allocated time. But I'm certainly sensing the reluctance to engage in any conduct that translate into a delay in the matter, however short. But it's only on that consideration that I will agree and hold to your timelines in terms of your submissions.
We're in that
In the circumstances, the matter then will adjourn tomorrow at 10 a.m.
My lord, could I beg your indulgence? I'm not questioning your lordship's ruling, but I wonder whether your lordship or my learned friend could give some sort of a commitment by when we will get this affidavit.
Yes, no, the affidavit has to be delivered today by close of business, so that we don't have any other issues hanging around.
Dated to watch.
We commit to that.
All right.
Take your opinions.
I think we're good, eh?
Yeah.